Prior to joining the AAPD, Mr. Imparato was General Counsel and Director of Policy for the National Council on Disability. Mr. Imparato graduated from Yale College and Stanford Law School.
Thank you very much, Congressman Andrews and Ranking Member McKeon and everybody on the committee for being here and for having a hearing on this very important topic. As a Baltimore resident, I also want to acknowledge one of our representatives, Congressman Sarbanes. It's great to see you here. And our children play piano together, so it's good to see you in another context. You know, I wanted to start just by saying I'm here as an attorney who graduated from law school in 1990, the year that the Americans with Disabilities Act was enacted into law. I personally have bipolar disorder and manic depression, and I'm one of thousands of professionals who have developed our careers in the context of a law that protected our civil rights. And I've been very open about my disability, and it hasn't kept me from accomplishing my career goals. And I think that was one of the things that those of you who were here and worked on the ADA the first time around were hoping would happen. So I wanted to start in that positive vein. I'm testifying today on behalf of the American Association of People with Disabilities, which was founded on the 5th anniversary of the Americans with Disabilities Act. And our mission is to organize the disability community defined broadly so that we have more power politically, socially, and economically. I also want to join Majority Leader Hoyer in acknowledging Cheryl Sensenbrenner, who's the chair of my board at the American Association of People with Disabilities. And I want to acknowledge Majority Leader Hoyer and Congressman Sensenbrenner for their leadership on this bipartisan effort. The ADA Restoration Act is the top legislative priority for AAPD, and we believe it's critically important that the ADA's protection of equal employment opportunity be extended to all the people who Congress intended when you passed the ADA in 1990, including people with epilepsy, diabetes, cancer, depression, intellectual disabilities, and a whole host of other conditions who have been told by federal courts that they aren't disabled enough to have civil rights protections. The ADA gave hope to millions of Americans with disabilities, and we must pass ADA restoration so that we can restore that hope for people like my colleague Carrie McClure, who you're about to hear from, who have been removed from the ADA's protections by activist judges. On a personal level, because of what the courts have done to the ADA, I no longer believe that I can count on the law to protect me against employment discrimination. At a minimum, if I were to bring a case, I would be subject to a barrage of personal questions that have nothing to do with my qualifications on the job. The ADA is not a disability retirement law, but the Supreme Court and the lower federal courts have gone out of their way to read the ADA as if it were only for people with disabilities that are so significant that they cannot work and cannot take care of themselves. Under this narrow reading, two of the ADA's strongest legislative champions, Tony Coelho and Bob Dole, would likely be told by a federal court that they are not disabled enough to be protected by the ADA. Employment discrimination cases should be about how a person is treated in the workplace. But because of Supreme Court decisions like the 2002 Toyota versus Williams case that Majority Leader Hoyer referenced, we've come to a point where the Supreme Court has opined that the term disability is to be, quote, interpreted strictly to create a demanding standard for qualifying as disabled, and victims of disability discrimination are finding it harder and harder to reach the issue of how they were treated by their employer. Citing the Williams case, the 11th Circuit ruled last May in Littleton versus Walmart that a 29-year-old with an intellectual disability who was receiving Social Security disability benefits did not submit enough evidence to establish that he had a disability for purposes of the ADA. Examining whether Mr. Littleton was substantially limited in a major life activity, the 11th Circuit stated that, quote, it is unclear whether thinking, communicating, and social interaction are major life activities under the ADA. The court went on to use evidence about Mr. Littleton's ability to drive and be interviewed for a job against him on the issue of his disability. And I just want to briefly mention the broader policy context for this legislation. This is a committee that oversees the Individuals with Disabilities Education Act, the ADA, the vocational rehabilitation legislation. And I ask you as a committee, what is the message that you want to send to people with disabilities? Do we want to send 18 years after the Americans with Disabilities Act the message that you should be careful not to achieve to your full potential, be careful not to live as independently as possible, or you may lose your federal civil rights protections? That's the message that the court decisions are sending to people with disabilities. That's the message that a lot of our disability benefit programs are sending to people with disabilities. Those programs need to be modernized, but certainly in the area of civil rights, we should be sending the message that people with disabilities should achieve to their full potential, should enjoy their civil rights protections, and cases of employment discrimination should turn on whether they're qualified for the job, not how disabled they are.